Okay, so in chapter 11, the author talks about tort, which is an injury to another person or property, and the goals of tort law is to compensate innocent persons who are injured or whose property are injured as a result of another's conduct, to promote a just society by forcing responsible parties to pay for the injuries they've caused, and to deter future wrong. Types of the tort damage would be compensatory, nominal, and punitive. The classifications of tort would be the intentional, negligent, and strict liability torts. Intentional tort involves purposeful actions that the defendant knew or should have known would cause harm to the person, property, or economic interest of the plaintiff. Sorry, I can't read my handwriting. Negligent tort is failure to live up to the standard or care that a reasonable person would meet to protect others from an unreasonable risk. In the strict liability tort, is the defendant is engaged in an activity that is so inherently dangerous that no amount of due care can make it safe. The global dimensions of the tort law are the extent to which a U.S. judgment will be enforced to a foreign nation depends on the nation's law. The U.S. judgments are not accepted globally, and the U.S. business managers will have to become increasingly familiar with the policies of foreign courts. And then in chapter 12, it talks about the theories of recovery in product liability cases, which would be negligence. I don't know why I keep struggling with saying that word. The breach of warranty, and the strict product liability. The market share liability is a plaintiff is unable to identify which defendant caused his or her injury. The service liability is it occurs when someone or someone's property is harmed because of the inadequate performed service. The malpractice suits are the service liability suits brought against professionals based on a theory, negligence, breach, or contract of fraud. And accounts liability, the plaintiff is required to prove duty, breach of duty, causation, and damages. And then the global dimensions are when an imported product causes injury to a consumer is in the U.S. is sold, the plaintiff can sue the retailer or wholesaler who sold it to them rather than the manufacturer who is located in another country.